Right, so carrying on with mortgages and seeing how that they can be freed from the equity of redemption, how the mortgagor can really get the property and the debt's paid off. So a mortgage can have terms in it which might be giving some advantages to the mortgagee as well as the security. Quite often it's like in tied public houses. So public house is a place that sells alcoholic drinks for consumption on the premises. And for instance, it might say that you can only buy your alcoholic drinks from us, the brewery, or from a certain brewery. So as long as the collateral advantages are conscionable and not a restraint of trade, then these will be allowed if they're supposed to cease with redemption. Once the debt's paid off, then you're no longer tied to that term. But the aim of these is if these are aimed to continue beyond redemption, then the position is uncertain. The courts are more and more showing a willingness to uphold these advantages and saying, well, they're not strictly connected to the mortgage or collateral, and that's by Craiglinger the case, so long as they don't make this a right of redemption fallacious. Once again, this shows that freedom of contract is what's upheld in commercial mortgages. However, permanent fetters are still invalid. Noakes and Rice, 1902, found that. So the court might rule that the mortgage and the advantage form of the same transaction, it might construe the agreement as in substance being not only a mortgage and say it's not governed by this equitable rule that redemption has to be without conditions. So restraint of trade, this is anything which prevents someone trading as he or she wishes, buying from whoever he wants, selling to whoever he wants, varying the price, and that goes against public policy. Courts will strike it down. Nordenfeld and Maxim Nordenfeld, Guns 1894 is a case about that. It goes against competition. The doctrine of restraint of trade is applicable to mortgages. It's because there's public interest and is usually being used to attack tie clauses. For example, a mortgage of a petrol station or a public house saying that you could only buy what you're going to sell from one supplier, the mortgagee. Essa Petroleum Company Limited and Harper's Garage, Stourport Limited, 1968, or indeed Alex Lobb Garages Limited against Total Oil Great Britain Limited, 1985. Anyway, so some terms are held to be oppressive or unconscionable. Equity could step in if there were oppressive bargains. The courts have a broader equitable jurisdiction to nullify terms in a mortgage that they consider to be oppressive. So the courts usually don't exercise this prerogative. So they'll only do so where someone's put in an objectionable term, and this is really immoral. For instance, exploiting the bargaining position, dominant bargaining position. Now, of course, you can, to a reasonable extent, you can push a hard bargain, but there comes a point when it's just way too far. How far is too far? That's a moot point. The courts are loath to intervene if it's a business against a business, because they're ruled to have equal bargaining power. But that's really not true. You might be a multi-billion-pound corporation against a corner shop. Anyway, so it's not seen as enough that the term is unreasonable, or that one of the parties is doing badly out of this. City Land and Property Holdings Limited against Dabra, 1968, is a case of that. Multi-Service Bookbinding Limited and Marden, 1979, or indeed Alex Lobb's Garages mentioned herein before. In Multi-Service Bookbinding Limited and Marden, it was found that the term might have been unreasonable, but it wasn't enough. That wasn't enough to make it oppressive or unconscionable. An objectionable term can be removed if it was seen as morally reprehensible. That's what they said in that case. In Paragon Finance PLC against Pender, the Court of Appeal found that although the claimant's power to vary the interest rates for the mortgage was subject to implied term, these would be exercised properly and not whimsically. This didn't stop the lender from raising interest rates above those of competitors when he was raising them for real commercial reasons. The rates charged were not disgustingly excessive. So let's look at the statutory provisions. So one sector of unfair and unconscionable terms that is subject to statutory control is one we're going to examine now. For second mortgages or buy-to-let mortgages, the CCA 1974 and its 2006 update are relevant. The courts have the power to reopen unfair credit relationships as they have to do justice between the parties. When they're judging whether a particular credit relationship is unfair, the courts have to consider the factors in the Act. An unfair credit relationship is unfair to the debtor if any of the following are present. And there are three factors. One, they have to look at one, the terms of the agreement or related agreement. Two, the way in which the creditor has exercised or enforced the rights under the agreement or any related agreement. Or three, any other thing done or thing which has not been done by or on behalf of the creditor, either before the agreement or after making the agreement, or any connected agreement. The CCA, both 1974 and 2006, is applicable to mortgages where one party is an individual. The CCA 2006 has given the courts greater latitude about ruling agreements that are unfair. So so for first mortgages for residential purposes, after 31st of October 2004, if they're owner-occupied, the Financial Services and Markets Act is there, and it says it stops excessive charges, and a look at what the market average is. So so that there are certain rights of a mortgager. So a mortgage is a contract creating a proprietary right which can be legal, right? And that's per section 1.2c of the Law Property Act 1925. So remember, for a mortgage to be legal, under the unregistered land, it comes under section 85 of the LPA 1925. In registered land, if it's before the LRA 2002 as unregistered land. In registered land, if it's after the LRA 2002, it's as per section 85 of the LPA 1925 and section 23.1a of the LRA 2002, which is obliged as registration, and section 27.2f of the LRA 2002. If it's going to be equitable, then it has to be over an equitable interest, as in section 53.1 C of the LPA 1925. If you wish to create an equitable mortgage, then you have to follow section 53.1a of the LPA 1925. If you fail to create a legal mortgage, then it must meet the requirements of section 2 of the Law Property Miscellaneous Provisions Act 1989. Registered land after 2002 is number 27 of the section 27 of the LRA 2002. So remember, there's an equitable right to redeem, and the postponing it must not effectively defeat this right to redeem. A removal of collateral advantage. Okay, so the courts have to balance freedom of contract and the advantage must stop with redemption. They can gain some sort of advantage, the mortgagee, but once redemption's had, they can have no more advantage. And remember, unconscionable terms can be got rid of. It's a common law principle. If a term is not simply unreasonable but has to be really oppressive, then the courts will intervene and strike it down. There's statutory provisions to that effect. So they're going to tell you a bit more about the rights of a mortgagee, and that will really keep you entertained. So a mortgagee can sue for any money due, but there are other ways that he can enforce a security. If he wants to recover the capital, he can end the whole mortgage transaction. They could sell the land or foreclose. But they might want to preserve the mortgage, but to intercept rents and profits from the mortgaged land, they could enter in possession. They could appoint or they could appoint a receiver. But anyway, the power of sale is usually the remedy that they go for. So what's the debt action? Bear in mind that this is a contract we're talking about. If the debt is not repaid, the mortgage can be recovered. But there are some procedures to protect the rights of the mortgagor. So before you can commence a debt action, the mortgagee has to make sure that the legal date for redemption has passed. That's the date that the contract said the mortgagor could repay the debt. Anyway, in the old days, it couldn't be before or after that date. Now this date is usually between 1 and 6 months after entering into the mortgage. Equity has made this legal date unimportant, and the repayment of the debt is still important for triggering particular rights of the mortgagee. So the remedy is of little use if the mortgagor has failed. If he hasn't made the payments, he's probably not able to do so anyway if you start this action. And there's some limitation to this. West Bromwich Building Society and Wilkinson 2005 is a case about it. So there's power of sale. If a mortgagee mortgages through the deed, the mortgagee is the statutory power of sale. He can exercise that out of court. But the power arises when the mortgage money becomes due, as per section 101 of the LPA 1925. And that is not exercisable until three conditions have been satisfied, as per section 103 of the LPA 1925. And these are about default by the mortgagor. Here are the three conditions. 1. The default in complying with the notice to repay any of the mortgage money for 3 months. They've got to be at least 3 months behind. 2. An interest remaining unpaid for 2 months after it becomes due. That's the usual reason they give, because that's the interest, not the principal. 3. Breach of some other condition of mortgage, and Ladsky against TSB Bank 1997 is a case about this, as in leaving the house in a state of disrepair. They meant to keep it in good condition. So the power is exercised by the mortgagee starting a contract to sell. Lord Waring against London and Manchester Assurance Company Limited 1935 is a case about it. So the mortgagee is not a trustee of the power of sale, but has broad discretion about organising the sale. They have to act bona fide, and they have to be reasonably careful in trying to get the true mortgage value. So Cuckmere Brick Company Limited and Mutual Finance Limited 1971 is a case about this, where the mortgagee was found to be negligent by not publicising the terms of planning permission granted over land fully, accurately and in a timely manner. The mortgagee wasn't obliged to spend money or to take positive steps. For example, he didn't have to apply for planning permission to increase the value of land or to get a higher sale price. That was found in Sylvan Properties Limited against Royal Bank of Scotland 2003. Now, people often say the mortgagee can choose the time for sale, and they don't need to sell by public auction, or they don't have to try public auction, but try it before going for a private contract. It's unclear whether they're on a duty to sell or to take a reasonable care in making these decisions. The sale has to be a true sale. It can't be a sale by the mortgagee to themselves. And there's no rule that the mortgagee cannot sell to a company in which he has an interest. The court has to be confident that the sale is bona fide, and the mortgagee has taken reasonable steps to try to get the best price reasonably available. It doesn't have to be absolute highest, but it can't be ridiculously low. And Che Kwong Lam against Wong Chit Sen 1993 was a case about that. When the mortgagee sells, it's his duty to try and get the best price. The mortgagee, as we know, has the right to choose whenever it's convenient for him to sell. The mortgagee, even though if the mortgagee had waited longer, he might have got more money, that's okay, he can sell sooner. In Meftar against Lloyds TSB Bank PLC 2001, that was found. The mortgagor can apply for an order to be allowed to control the sale under section 91.2 of the LPA 1925, and the mortgagee's objection to the sale could be overridden by the court, depending on the situation, as in Palk against Mortgages Service Funding PLC. The statutory provision here says the court has unlimited discretion to stop manifest unfairness by either side, and this allowed the mortgagee's needs, financial and social, as per Palk or indeed Polonsky and Lloyds Bank Mortgages Limited 1998, to be considered. So it might be possible for there to be a postponement of possession under the section 36, and that will permit the mortgagors to stay put there to control the sale, because they might be in the best position to get the best price. Target Home Loans against Clothier 1994, but there's no general principle the mortgagor can control the sale simply because he's in negative equity. That's as per Cheltenham and Gloucester against Krause 1997. When there's a sale, the mortgagee sells free from all interests apart from mortgages prior to his. When they sell the mortgage's title, there's no need to overreach the interest in which they already have priority. That's because they already have priority. So the purchaser takes the whole interest vested in the mortgagor, subject to prior mortgages, but free from all interest to which the mortgage has priority. For instance, equitable interest behind the trust are overreached. The mortgagee is a trustee of the proceeds of sale, and they need to apply in a particular order, as per section 105 of the LPA 1925.